G'day everyone, and welcome to the third video in week 3 of our legal ethics course. This week we're looking at the vital topic of admission to the legal profession and how the admission process intersects with questions of ethics. In the first video we looked at the general requirements for admission, and in the second video we looked at the admission process. In this third video we're looking at some of the pitfalls. What are the reasons that are likely to prevent you from practicing law? These are set out in Section 9 of the Legal Profession Act, a section which you should come to know very well as your own admission approaches. We can group the suitability matters into a range of categories. First, there are those relating to bad behaviour. Second, there are those relating to financial incapacity. Third, there are those related to improper practice of law. And finally, there are those related to health. Before we come to those categories though, there's one suitability matter which stands out all on its own. Paragraph 9(1)(a) says that whether a person is currently of good fame and character is a suitability matter. Read on its own terms, the idea of good fame and character is intensely problematic. How on earth does a court test the public reputation of a person? How on earth does a court test the character of a person? In reality, it's just impossible. Justice Black of the US Supreme Court, in a case called Konigsberg and the State Bar of California, quoted by Isaiah Ross in his textbook, said the notion of good fame and character can be defined in an almost unlimited number of ways, for any definition will necessarily reflect the attitudes, experiences, and prejudices of the definer. In practice, good fame and character serves two purposes. First, it gives the court a means of rejecting people who are clearly unsuitable for practice, but whose unsuitability doesn't fall neatly into one of the other categories. Second, good fame and character really focuses on the idea of honesty. Courts fundamentally rely on practitioners to be honest. All of the key cases around good fame and character rely on dishonesty. One of the most famous modern ones is the Wentworth case. Kate Wentworth is or was one of those sad, self-represented litigants that you sometimes encounter in your career, who become so obsessed with their legal disputes that they are literally unable to see or think of anything else. Often they reach the point of generating conspiracy theories. That happened to Kate Wentworth, who engaged in litigation after litigation after litigation for more than 20 years, from the 1980s until well into the new century. She was consistently unsuccessful and had a habit of consistently arguing that judges and other lawyers were mistreating her. She constantly asked for judges to recuse themselves. Along the way, in the late 1980s and early 1990s, she managed to acquire a law degree and applied for admission as a barrister in New South Wales. Admission was refused. Then, as luck would have it, she became the very first applicant before the new Legal Profession Admission Board in 1994. Her application was denied on the basis that she had abused the powers of the court and been dishonest in her submissions before the court. She appealed ultimately to the High Court and lost on every occasion. In the end, in 2007, the court issued injunctions against her making certain types of application. What crucified her, though, was the dishonesty. The fact that she had made and sworn dishonest statements made her completely unsuitable as a practitioner. Similarly, academic dishonesty won't be tolerated. It's not the academic dishonesty itself, although that's bad enough. For many people, when they make their application for admission, university is virtually the only thing they've done in their adult life. And so it's the best chance the board has to see what sort of person they are. I've already talked to you about OG's case, where a student, GL, was denied admission after they were found colluding with one another on an assignment which should have been completed individually. I have to say I'm still not convinced about the whole concept of good fame and character. If they mean that a sustained record of dishonesty should prevent you from practice, then that's what the law should say. Let's move on though and look at the suitability matters relating to bad behaviour. Paragraph 9(1)(e) of the suitability matters says that a suitability matter is that a person has been convicted of an offence in Australia or overseas. But it all depends on the nature of the offence, how long ago the offence was committed, the age of the person when the offence was committed. The latter two are fairly obvious. The longer back in time the offending was, the more likely the offence is to be forgiven. And the younger the person was at the time of the offending, the more likely the offending is to be forgiven. In a long ago case called Ex parte Lenehan, the High Court said, the false steps of youth and early manhood are not always final proof of defective character and unfitness. The presumption they may appear to raise may surely be overcome by a subsequent blameless career. The first of the criteria, though, is a little more complicated: the nature of the offence. First up, any sort of offending involving dishonesty is going to be taken very seriously. Second, any sort of offending which attracts really serious public anger is going to be taken very seriously. So, for instance, anyone convicted of murder or sexual assault or offences against children is pretty jolly unlikely to be admitted. Finally, offences that show a deliberate disregard for the law are going to be taken seriously. So, drink driving offences, drug offences and so on. On the other hand, minor offences such as, say, speeding offences are unlikely to be an issue. Additionally, offences of strict liability and offences of absolute liability, so offences that do not require mens rea, are likely to be treated more leniently because the offending may happen even when a person has absolute regard for the law. The second type of misbehaviour relates to a person who has been subject to professional misconduct in another profession. The Queensland District Court recently had occasion to consider this in a matter in which I appeared. In the matter, called Rich and Oswide, Rich sought to be represented by a Stephen Aruligan as a lay representative. Aruligan, it turned out, had completed a law degree and practical legal training and had applied for admission as a practitioner, but his admission had been stalled. The judge, refusing him permission to appear as an advocate but allowing him to appear as a Mackenzie friend, which is kind of like an assistant, the judge noted that Mr. Aruligan had previously been a pharmacist but was prohibited from practicing as a pharmacist after he was jailed for removing drugs from his pharmacy and then failed to comply with the disciplinary rulings imposed as a result. The judge took these matters into account and noted that they might well be relevant to his admission. The next group of suitability issues relates to financial issues. There are a few of these in paragraphs 9(1)(b), c, d and m. They boil down to some fairly simple propositions though. If a person has been bankrupt themselves, or if they've been the director of a company that's become insolvent, and especially if they've been the director of a legal practice that has become insolvent, then there are obviously very serious questions to be asked about whether that person can be placed in the position of responsibility inherent in legal practice. Again though, these are just suitability matters. There's no general rule that a person who has been bankrupt or a person who's been the director of a company placed in receivership can't be admitted to practice law. There may be any number of reasons why a person becomes bankrupt. For instance, there's the phenomenon sometimes referred to as sexually transmitted debt, where at the end of a marriage, one of the parties may be left with a mountain of debt that they didn't even know about during the course of the relationship. Similarly, for instance, in the COVID years of 2020 and 2021, a great many businesses became insolvent, and it'd be just impossible to argue that this was because of any moral failing on the part of those business operators. This is exactly why the crucial thing is, during the admission process, to disclose all of these factors. Disclose, explain, and then the board and the court can give you fair consideration. The next category is super important. A person who has practiced law improperly or unlawfully in the past will obviously face suitability concerns. This issue arises in paragraphs 9(1)(f), G, H, I, K and L. Basically, if a person has practiced law while they were not lawfully entitled to practice law, or if they've been struck off the roll anywhere in Australia or anywhere overseas, or if they've practiced in defiance of any conditions imposed on them, or if they're seeking admission in one jurisdiction while being under investigation in another, or if they've been found to have improperly operated a solicitor's trust account, well, surprise, surprise, any of these things is likely to be regarded as a very serious suitability matter. Finally, we come to issues related to health. Generally speaking, physical health is pretty unlikely to interfere with admission. I've had the pleasure of teaching students with a range of physical disabilities, and it would be quite obviously contrary to human rights principles to deny those lawyers the ability to practice. However, brain injuries or conditions affecting cognition could quite obviously affect the capacity of a person to practice. Psychiatric conditions such as schizophrenia or psychosis could obviously affect a person's capacity to practice. Psychological conditions such as severe depression or anxiety might potentially affect a person's capacity to practice. Alcoholism, similarly, might affect a person's capacity to practice. This is, however, a pretty huge double standard. Once you're through the door of admission, the same standards don't seem to apply. Mental health issues, particularly depression, anxiety and vicarious PTSD, are endemic in the law. Alcoholism, I suspect, is perhaps not quite the size of a problem it once was, but it's still there and in a big way. These things might affect a person's admission, but once they're admitted, they don't tend to be grounds for discipline or removal. Now, some of you may well be a bit concerned having listened to all of this. Some of you may have, in the dim, dark past of your personal histories, things that you have just learned you will have to disclose to the board. In many cases, this should only cause you the briefest moment of anxiety. But if you really are concerned that you may have a suitability issue which might get in the way of your admission, Section 32 of the Legal Profession Act provides for a person to apply for early consideration of suitability. This is only open to a person who considers that they may have an adverse suitability issue. So you can't just apply for early consideration as a matter of course. If you do apply for early consideration, and if you give full and frank disclosure of matters that might be suitability issues, then the board is required to consider those issues. If, having considered those issues, the board is of the view that the matters disclosed should not prevent you from being admitted, then the board can make a declaration to that effect. A declaration of that type is then binding on the board when you make your final suitability application. So you still have to jump through the rest of the hoops, but you have the security of knowing that the matters disclosed to the board won't affect you. On the other hand, if the board's view is that your suitability matter will prevent you from being considered suitable, well, at least you know that up front before the end of your degree. Okay, this brings us to the end of video 3. In this video, we've walked through various matters that prevent a person from being considered suitable for admission as a lawyer. We've considered issues of honesty, criminality, financial incapacity, the improper practice of law, and issues of health. Finally, we've learned about the process of early consideration, which may help if you're concerned that you may have a suitability issue. Now, believe it or not, admission is not the end of the road. Even once you're admitted, you're not yet allowed to practice. For that, you'll need a practicing certificate. And so in the final video this week, we talk about practicing certificates and the obligations that come along with them, particularly the obligation to undertake continuing professional development. See you in video 4.